Okay, we'll move on now. I'll now move on to when you should recommend that your company obtains overseas trademark protection. Now, at the outset, unless you have experience with overseas trademark protection, I do not recommend that you do overseas applications yourself. As I mentioned, trademark law is a jurisdiction by jurisdiction system, and the law, the procedure and the fees can change from jurisdiction to jurisdiction, and they can change quite substantially. For example, I can think of 3 different ways to actually file a trademark in France, and each of those 3 different ways have significant advantages and disadvantages. So it's a case of just getting advice before you act. So when should you recommend that your company obtains overseas trademark protection? Well, there are 2 main situations. The first is when the company is seeking to trade in another jurisdiction. And I'd suggest here that you look at where your company is intending to trade in the next 5 years and then go and register in those jurisdictions. Now, trading in another jurisdiction includes online trading. So if your company is setting up websites directed specifically at other countries or providing goods or services into those countries, then they are both situations when they should look at a registration in that country. The second situation in which you should seek overseas protection is when your company is manufacturing goods in another country and has the brand name applied to the goods in the manufacturing process. Now, the case in point here is China. Many manufacturers, many Australian manufacturers, have their goods manufactured in China. They have the brand name trademark stamped on the goods during the manufacturing process. They then have the goods shipped back into Australia and they sell them on the Australian market. Now, the issue that these traders may face is that, unlike in Australia, where we have what's called a first-to-use trademark system, in China they have what's called a first-to-file trademark system. Now, what that basically means is the first person to file a trademark in China and get a registration is the owner of that mark, regardless of what has happened beforehand. So the dangerous situation that occurs is that these Australian manufacturers can be manufacturing goods over in China, having the goods stamped with the trademark, having them shipped back in for a long period of time, say 4 years. They can invest expense into this, and then someone can come along and register their mark in China and tell them to stop using it. And obviously that interrupts the whole manufacturing process. Finally, before leaving overseas protection, I should mention an issue as to timing. When it comes to trademark applications, many rights are measured as at the date of filing. If a company files a trademark in another jurisdiction within 6 months of filing its corresponding application in Australia, it may be possible to claim the Australian filing date as the effective filing date in that other jurisdiction. Now, this is important because the company's effective filing date determines its place in the queue against other applications. So that is why you need to be aware of when to promptly recommend overseas filing at the outset when you're actually dealing with the Australian application. I'll now move on to one of my favourite areas, which is domain names. Now, domain names are essentially internet addresses that are used to direct information. They may be used to direct users to a web page, or they may be used to direct information to an email facility. So, for example, you can find the Victorian Bar's website through the vicbar.com.au domain name by entering www.vicbar.com.au in your web browser. Or you could also email members of the bar through using the same domain name by, for example, entering their surname, then the @ symbol, vicbar.com.au, and hitting send. Now, the registration of a domain name gives your company a license to use that domain name in ways such as I've just described, subject to conditions for a set period of time. However, one of the greatest concerns of many companies is not to register domain names in order to use them, but to prevent others registering domain names that are similar to their brand name. Now, this is a real concern because it's cheap and easy to register a domain name from just about anywhere in the world and then go on and use that domain name for fraudulent purposes. For example, there is a practice which many of you, if not all of you, would have come across called phishing. That's phishing spelt with a PH. Anyway, phishing involves sending messages such as emails, pretending to be a brand owner or another person in order to try and elicit or extract information out of the recipient and then go and use that information for fraudulent purposes. Now, in my opinion, phishing is not only a great threat to consumers, but it's also a great threat to brand owners, because you could imagine the damage that would be caused to a brand if even only one customer or client responded to one of these emails, and the next thing they know, their whole bank account's been drained to Nigeria. So what can your company do about this problem? Because obviously it cannot register every domain name that's out there. It cannot register its brand name followed by every domain name extension because there's just too many. However, at a bare minimum, all brand owners should register their brand name followed by the .com and the .com.au domain names extensions, which are the most popular and most used domain name extensions in Australia. What you register after that is really a matter of cost versus benefit. If you're a large company requiring many domain name registrations, you might be able to keep your costs down by using a domain name portfolio manager or by setting up a management system within the company that ensures that renewals take place and the domain names don't lapse. Also, if your company wants a domain name that's already registered, or is unhappy that somebody else has registered a domain name that is similar to their brand name, don't tell them that nothing can be done, and or that nothing can be done without spending considerable dollars, because there are actually multiple cost-effective ways to obtain a domain name that has already been registered, particularly in the .au space, which is a highly regulated space. So it's a case of seek advice on your options and see what can be done. Of course, one of the other major mediums for use of brand names online is through social media. Sadly, social media has provided an opportunity for fraudsters to infringe trademarks and benefit from the reputation of trusted brands. The social media industry has responded to this threat by providing notice and takedown complaint services. Now, notice and takedown basically means that trademark owners and copyright owners can file an online complaint with the website, with the social media website, that content on the site infringes their rights. The site owner will then review the complaint and notify the offending user, and the content can be promptly taken down or removed. Now, each of the major social media sites has their own policy and complaint services. This is important for them to maintain defences and distance themselves from infringements that can potentially take place on their sites. It's particularly important over in the US and the European Union, where they have legislation which actually encourages them to take up these services. Now, I've included on the slides links to Trademark's notice and takedown services for 3 of the major social media sites. Now, I've used all 3 of these services. I found them relatively straightforward and fairly simple to use, especially if you do have a registered trademark and your complaint is based on the rights within that registered trademark. So it is something that you can definitely do yourself in your in-house teams. Now, as for each of the particular services, I've found LinkedIn very helpful, very fast. That's my experience with them. They communicated quickly, told me when the information was taken down, and it was taken down quickly. Facebook, I found, were extremely fast in taking down the information that I complained of, but they didn't tell me. I didn't get any emails or phone calls from Mark Zuckerberg or anything like that. So it's really a case of having to go back on the site and have a look and see whether it's been taken down. And Twitter, I've only had to do one takedown on the Twitter site, and this has been recorded, so I might have no comment on my experience with Twitter, but it may have been an isolated one, but it was painful. Now, just one final point. When you're dealing with these takedown services, just do be aware that when you request a takedown, don't expect that the social media site's going to keep the content and keep the evidence. So if for any reason you do require that evidence for another proceeding, perhaps get advice before you go and request a takedown. And most certainly, even if you're not thinking that you need that evidence later on down the track, all the same, still take a screenshot or a screen capture of the infringing material, it's fairly simple, just print it out, and document what you're doing, as in when did you see that material, on what page, what link did you click on. The reason being that by the time you complain, the material might have disappeared, or it might have moved to somewhere else. Another tip is, when you're putting in these takedown notices, do be polite and friendly and keep you obviously have to enforce your company's rights, you have to be quite clear, but you're not writing a letter of demand. You're actually writing to somebody whose job it is at Twitter or Facebook to sit there and deal with these complaints day after day. So in my experience, you will get a lot more positive result if you are polite in your dealings with them and don't treat them like the infringer. On that point, I'll finish up today with some final tips on brand name protection situations where you should act promptly or seek further assistance. Now, I've already told you about trademark registration, but what I just want to emphasise at the end here is act quickly. Many rights are determined as at the date of filing an application to register a trademark. So either file it or flick it. You don't want the query sitting on your desk when a competing trademark is filed before your company's. The only qualification I would add is if your company's brand name trademark is one that they have just developed, then you should suggest they obtain a trademark availability search and opinion. This will let the company know if there are any pre-existing marks out there that are going to cause problems to them obtaining registration or using the mark before they overcommit to this new mark. And you can outsource this service. There are companies out there that their main practice is doing search and availability searches. Next point on the slides, you shouldn't sit on a passing off query or your company's concern about another trader's mark. If that trademark of concern has been filed and accepted for registration, there are deadlines by which the company has a right to challenge that registration without having to go off to the federal court. Now, I've actually inherited a file before from another solicitor where one of those deadlines passed while it was sitting on that other solicitor, who was at another firm, I should mention, and they weren't at Griffith Hack. And one of those deadlines has passed while that other solicitor had the file, and that's not a situation you want to be in, because to just put in perspective the consequences of that mistake, The cost of running a trademark opposition through the Trademarks Office, which is how you object to a registration through the Trademarks Office, the cost of that is relative to a small civil magistrate's court matter, whereas the costs of obviously challenging a mark or a registration through the federal court is significantly greater. Also, if your company lets another trader use a trademark that is similar to its brand name trademark for a number of years, that other trader can possibly acquire rights and defences to continue to use the mark as an honest concurrent user. So inaction is not recommended. Obviously, action against an infringer commences with drafting and sending a letter of demand. Now, what you generally want in a trademark infringement is to stop the present infringing conduct, to stop similar infringing conduct in the future, and then you may also want damages or account of profits. However, they can be notoriously low and difficult to obtain in many trademark infringement cases. So your letter of demand should set out A, your rights, B, the infringing conduct, C, some carefully drafted undertakings that set out what you require the infringer to agree to, and B, a reservation of your rights and your further remedies. Also, when drafting a letter of demand, beware of making groundless threats. Those are threats that threats of trademark infringement that have no basis under the Trademarks Act or have a mistaken basis. Under the Trademarks Act, if you make such threats, damages can actually be awarded against you. So the important outcome from the demand in many cases will be receiving the signed undertakings. So what I suggest is include a signature clause in the letter of demand under the undertakings or at the end of the letter so that the recipient can simply sign and return. I have found that on occasions that has actually happened and that has resulted in a quick, good result. However, if you don't get a quick result and you urgently want to stop the conduct, you should promptly seek your advice on obtaining an interim injunction. Delay may affect your ability to get such an injunction. So that is generally how you approach an infringer. If, however, you're on the other side and you're the one receiving the letter of demand, you should also act quickly. Don't miss the opportunity to settle a losing matter early with undertakings, if it is a losing matter. The amounts involved in trademark infringement are often not worth it, and despite the series of demands that you've no doubt received, the person issuing those demands often just wants your company to stop the infringing conduct. Of course, there are exceptions, but that is the most common scenario. However, if you do not promptly communicate, you will be amazed how quickly some brand owners will litigate, and it is in a matter of days. Right, that concludes what I have to say today. The good news overall is trademark protection is not rocket science, and proper diligence does not have to be expensive, particularly if you tackle the issues quickly. Are there any questions? Yes?
A question around prior use with unregistered trademarks in particular. Question around prior use with unregistered trademarks. So your company has sort of a brand in mind or a particular trademark application in mind. The sort of searches you're talking about, do they search sort of common usage and business usage out there as well as just the trademarks register?
The question was in relation to prior use. do trademark availability searches also search for this prior use for unregistered trademarks out there in the marketplace? That's a very good question, and it's a problem that a lot of trademark professionals have faced. The simple answer is yes, when a trademark search is conducted, the trademark professional will search a number of databases, even things as basic as Google and other databases to see if there's anybody out there who's using the trademark without registering it, and therefore may have rights for prior use. However, it's just not possible for there to be a search that can detect all possible prior use that's out there. So it's just a matter of getting the best search you possibly can. What many search companies will do is they'll give you various options. So they'll say, if you want to pay this much, we'll sit there for 2 hours and start searching through absolutely everything, not just the trademarks register, but we'll search through every available database we can find to see if there's anybody out there using this mark in an unregistered form. And then there's other search options that may involve just searching the trademarks register for an exact match to that mark. So, and then there's everything else in between.
I understand with some dealings I had with IP Australia recently that they're going to include business name searches in their standard search as well in the coming months. So they'll also, come back with a hit, so to speak, if there's a registered business name for something that sort of represents or is part of a trademark that's being applied for as well. So, which is previously, as I understand, hasn't been the case either, and it's almost up to you to do that search.
Yep. Sorry, I'm just repeating the questions for the recording. The question was that it's understood that IP Australia will be including business name register searches in its examination process. I actually hadn't heard of that, but I'll be interested to see what the practical effect will be, because IP Australia also conducts basic Google searches and they see what's out there. But the reason they conduct those Google searches is to see whether the mark's descriptive, whether there's an objection on those grounds. They won't actually, at this point, they will not object to a registration on the grounds that there are unregistered rights out there. And it's actually it's a good point, it's another good reason to get a registration, because IP Australia at the moment, their examination practice is they do not look for unregistered rights. They regard that as an issue that private individuals or companies can deal with at opposition stage. So what they think is, or what they say is, if you have unregistered rights, such as you've been using the mark for 20 years and somebody else has gone to register your mark, but you've never registered it, well, you can come tell us that at an opposition and bring evidence. The examiners won't bring that evidence forward. Any further questions?
Hi, I was reading yesterday about a trend towards companies consolidating their brand portfolios, so effectively killing off a few brands to focus on the major ones. And obviously, use is a major part of maintaining trademark rights. So I was wondering what kind of strategies you'd recommend for protecting those legacy brands?
Yep, that's a really another really good question, because a while ago I actually had an opposition in relation to. Oh, sorry, I'll repeat the question. The question was that a number of companies are now consolidating their trademark portfolios, and therefore some of their older legacy brands are becoming less used, and what are the strategies for maintaining those legacies? Now, it's a good question, because a little while ago I actually had an opposition matter which concerned one of these legacy brands. And it was a very, very well-known brand back in the 80s and the early 90s. But the company stopped using it after a merger. And anyway, another company from overseas came in and said, okay, well, we want to register it. And therefore, they found our company's registration on the register, and they put in what's called a non-use action, which is they applied to remove our company's mark from the register on the grounds that it hadn't been used in the preceding 3 years. Now, our company had to squirm and wriggle and try and argue that the Trademarks Office should exercise its discretion not to remove the mark, even though we hadn't used it in the past 3 years because it was such a famous mark. That's very hard to prove, and ultimately I'm sorry to say that we didn't get up on that point. So the bottom line is, really the only way to protect a mark from removal for non-use is to use it and to engage in genuine use. Now, the use must be genuine. It cannot be use that is only designed to prevent a non-use action. But it doesn't need to be substantial. It can be 20 items. So for example, if you've got a registration for t-shirts, if you make 20 genuine sales of 20 different t-shirts at the local market, you've used that trademark in relation to the goods for which it is registered, and therefore you've done what you need to do for that 3-year period to avoid non-use. So really I think the easiest way to avoid that happening, to avoid marks being removed, is to use them even to a smaller extent. Any further questions? Okay, well thank you for your time.